Look, I get that it's not Wednesday. It is, in fact, a Tuesday, and we've already screwed up somebody's schedule saying, oh, Law Talk, it must be a Wednesday. It's not. It's Tuesday, and we had to make some arrangements because they've got day jobs, not just doing the free hour advice for you that you might need some criminal defense attorneys. Bruce Ringstrom Jr., Dane DeKrey in studio. Thanks for coming on over, fellas.
Glad to be here, Tyler.
Dane, you too?
Okay. No, I'm glad to be here, of course.
Yeah,
of
no,
course.
It's always a pleasure having you guys. And if you have any questions, now's the time. And, Gay, this is a game changer. We got our phone lines back. If you want to call in at 237-5948 or 1-800-880-5346, you can go ahead and do so. You can also text in to 35270 and get all your questions answered for you, because you always have a pal that did something that might be a little stupid. And they got answers for you. But, folks, I wanted to ask you, too, this question when it comes to juries, because there's a couple of things. One in our backyard, one that's been now on a national display when it comes to a former president being convicted on 34 felony charges. I want to start with the jury selection process, and then we'll get to what happens if somebody tries to tamper with the jury, because it seems like a logical way to go about this. Bruce, I'll kick this to you, because we've now seen in New York where this whole very public process, and last month when we talked, we were discussing about high-profile clients. You guys have had experience with that and all the ins and outs that come with that. But I'm curious, because now since that jury has come down with a guilty verdict of the former president, you have people like North Dakota Governor Doug Burgum saying, well, the jury was all Democrats. The jury was out to get. He didn't get a fair trial. As a criminal defense attorney, what's the process from you when it comes to jury selection?
Picking a jury is very often the most important part of a trial. The right jury will take seriously the evidence that you put in front of them. The wrong jury won't. Jury pools matter. So, for example, if there's a very public case in Clay County or Cass County, the jury pool might be so particularly prejudiced that the defendant cannot get a fair trial there. I did not follow the trial in New York City, but certainly if you look at the demographics, it's likely that, at least from a political perspective, the jury pool was less likely to be favorable to Donald Trump than somewhere else, if they were in Texas or any number of other places. But that's separate from jury selection as a whole. The questions, the inquiries are such that what you are trying to do is find the prospective jurors who would not be a good fit for your trial. It's actually a process of jury deselection.
So the line of questioning is going to weed that out, I imagine. I imagine the line of questioning, of course, is different in every trial, trying to deem, do you, I guess, let me ask this. Have you ever asked, hey, who'd you vote for in the last election?
I've never asked anyone that, but I have come to learn that some attorneys do, in fact, ask that question. I always thought that was sort of verboten. You're just not allowed to ask that kind of question. But questions in jury selection can be extremely intimate and private. Things about people's sexual experiences, or whether they've been victims of violence, whether they know anyone who's been imprisoned, whether they have thoughts and feelings about someone of a different race or background. Sometimes the questions get so intimate and so personal that a judge will have that prospective juror answer those questions in chambers, what's called in camera, away from everybody else, because it would be really hard to talk about things that you might not have even spoken with a therapist about.
Wow. We are having this conversation with a friend of mine, of course, about this verdict, and there was a moment that he was called to serve on a jury, and it was about a case that involved a driver who was impaired, got in a car accident that had injured somebody else. And, of course, he was going to be his own defense, and one of the questions was, have you known anybody, or have you or yourself been involved in an accident that involved someone that was drunk driving? And he was shocked that it got to that level of detail, and, of course, he did know at least 3 people, and he was quickly removed from the defense. The defense said, nope, we don't want that guy part of it. I mean, that's pretty much how this works, right?
Yes, it is. There's 2 ways to get rid of a prospective juror. You can move, well, I should say there's 3 ways. First, a judge will typically ask a series of basic questions. Do you live within the county or the jurisdiction? Are you eligible to vote? Are you eligible to actually be a juror? And then other questions, whether they have any particular reason why they absolutely could not serve on this jury. Do they, are they related to the attorneys or the judge or the defendant or any of the main witnesses and things to that effect? Then when the attorneys start asking questions, they can make what's called a motion to strike for cause. If a prospective juror says, I cannot be fair to this defendant, or I cannot be fair to the government under any circumstances, even if the judge orders me to, that juror will be struck for cause. Once all that's done, then at the end, that's when the attorneys play the game of what's called peremptory strikes. We can strike them for any reason at that point. If we just don't like the way they look at our client, or if they pause too long to answer a question about something that's deeply relevant to us, we can kick them off the jury.
Dane, you have something to add to this?
There's only one important caveat there, is that you can't remove someone on a peremptory purely for an immutable trait. So like if they're black or if they're a woman, there's a Supreme Court case called Batson, and that does not allow that to happen because back in the day in our storied history, particularly in the South, prosecutors mostly would remove every black juror from a jury pool during peremptory challenges, thereby not allowing black defendants a jury of their peers. So that's illegal, but it's actually somewhat difficult to prove because let's say the prosecutor makes a challenge of a black juror and Bruce and I think it's not for any reason other than the color of their skin. We can say to the judge, Your Honor, we'd like a Batson challenge or we'd like a Batson explanation. And then the prosecutor has to give a non-race-based reason for why they're striking them.
Importantly, though, Tyler, that can actually be used against the defense as well. If I'm trying a case in a county that has a lot of Native Americans and I'm representing a Native American, and if I strike a white juror or a juror who's not Native, if I don't have a race or an immutable characteristic neutral reason for striking that juror, the prosecutor might have a Batson challenge against the defense.
The line of questioning out in New York, of course, we weren't a part of the jury. We weren't a part of the defense. We're just kind of speculating here. I know part of it was, okay, where do you get your news from? And I asked that in a high-profile situation. You've got high-profile clients of yours. Is that important, how close jury members may pay attention to the news? If they're very fluent in what news reports of something a client may have allegedly done, does that make it more apt for you to say, we don't want that person?
Well, it depends. I tried a case a number of years ago in Clay County where my client was on the front page of the Saturday paper here in this community, and I'm trying the case on the subsequent Tuesday. His face was on there, and he was charged with a particularly odious crime, and we inquired of the entire panel, and only one person had even seen the article. So it's not so much how informed people are with the news, although that does matter. Where they get their news informs us about the kinds of values that they have and the way that they think about information.
Interesting. Dane,
Yeah, I do think, and this is something that is important. I watched probably some of the trial more than Bruce did. I do think that the defense lawyers and maybe even the prosecutors in that case were not as forward-thinking and maybe strategic with their questions, because that's pretty low-hanging fruit to ask the question, where do you watch your news? Right. You're not going to get much out of prospective jurors with that. And if you do, it's still somewhat stereotypical stuff like, oh, if you listen to Fox News, you're going to be on Trump's side. If you listen to MSNBC, we want you. Well, that doesn't do you any good for the peremptory section because none of that's going to get you a cause challenge. And so the next level of jury selection is what Bruce talked about, which is deselection. And it's thinking very deeply about things that matter the most to the trial, that get to deep inner human emotions, that it doesn't matter what news you watch. If you ask the right question, it gets to the heart of who that juror is for the theory of defense in your case or the theory of prosecution. So I would just mention that.
Yeah, and a good example of that, Tyler, is the last trial that Dane and I had. Our client had a very specific characteristic, and that characteristic or his nationality is correlated with a certain stereotype. And so it's not a racial characteristic, it's a nationality characteristic. And I had to inquire of the jury about that and figure out who shared that stereotype. And we were able to find someone for whom it was really, really bothersome, and that allowed us to get that person taken off of the jury. It also caused conversation amongst the rest of the prospective jurors, so we had a better read on how they might think about that.
Is it equal parts prosecution and defense when it comes to the final selection of the jury, or not the case? I mean, that's probably such a naive question, but I think maybe you get what I'm building to here.
Well, and it depends on the jurisdiction. So, for example, in Minnesota State Court, both sides get an equal amount of time to actually inquire of the jury panel, or the veneer as it's called. In the end, the defense gets 5 strikes and the prosecution gets 3 strikes. Presumably that provides a little bit of advantage to the defense. Now, the state already has an overwhelming advantage in the sense that they actually called the case and they usually have almost all of the evidence. But it depends on the jurisdiction. You know, in Maine, for example, you don't even get to ask. You don't get any jury selection opportunity at all. You can strike jurors at the end, but you don't get to ask them these sort of detailed questions. In federal court here in the District of North Dakota, I've done jury selection in state court for 6 hours before, but in federal court, 10 minutes.
Dane, DeKrey, Bruce Ringstrom Jr., it's Law Talk. We're going to take your questions at 35270. I have one more question related to this, and that's change of venue. It was brought up just briefly. When we come back, we'll get to your answers next. It's Law Talk. Bruce Ringstrom Jr., Dane DeKrey taking your questions. I got some great ones coming in about DNA from Ancestry.com. Another one about a jury, though. That's kind of the topic we have this half hour. Tyler, can you ask if a 52-page document for the jurors to understand is over the top? I was on a jury that had 4 pages, and we as a jury had questions on it. So 52 pages, is that over the top when it comes to questions for juries? Dane?
You would hope so, but the counter to that is we just had our recent trial that Bruce mentioned, and I think ours was in the 30 pages. And the big difference in the case that I think they're talking about, obviously, is the Trump case, is you don't get to bring that back with you to the jury room in New York. And that surprised me. In our case, in federal court in North Dakota, it was 30 pages. The judge read it all in advance. Takes a very long time. You can see people's eyes gloss over because you're hearing a lot of high-level topics, some redundancies, it feels like. But we know that at least they're going to take it back to the jury room and be able to look at it. So I was not surprised at all that jury in New York came back and asked for some clarifying questions from a 52-page document with legalese that they couldn't bring back with them.
Bruce, anything to add to that?
I expect jurors to go back with the instructions. To me, it strikes me as odd that they wouldn't have that. I mean, these people are not familiar with the specific laws, and this is how they stay on task.
Final question on this that's kind of related to this Trump trial. Then we'll move on. People had said, well, there should have been a change of venue. And Bruce, you were talking about the fact that, New York, when you have the makeup, if it was somewhere else, maybe, different jury pool. What's it take? What's the threshold to get a change of venue?
Well, I wouldn't know how one would do it when the defendant is the most well-known person in the country. But certainly if we do a poll of the local community, we find that all of these people know about an alleged crime and are intrinsically biased against our client, we can put that information in a motion and ask the judge for a change of venue for a different county, for example.
Yeah, in Trump's case, it's very difficult because no matter where you go, everyone answers that same way. And so then it becomes forum shopping arguments. Oh, we should have it in Texas. Well, obviously, because that supports Donald Trump there, perhaps. Oh, let's keep it in Manhattan. And so I think the judge realized there's never going to be a great way to slice this bologna. And so it might as well be in Manhattan because that's where it's at. And I know they went for it. I know his lawyers tried it. And so they are very top-end lawyers. They would have made the best arguments that Bruce just mentioned. But a very notorious client makes it unique.
Send in your questions, 35270. Then the final half hour, we'll answer them about the DNA. We'll ask about the guy that was driving in, zoomed into court. Suspended license or not? We'll get that answer when we come back. Law Talk. Bruce Ringstrom Jr., Dane DeKrey. We'll get you the phone lines for you before the end of this show here at 5 o'clock. Okay, one more question about juries because we just heard during the KFGO News Update. $120,000 in a bag, which is like a gift bag. I thought it was a duffel bag. I've watched too many movies because it felt like it was something that you'd see on a movie. To a juror, and then having that juror excuse. Have you guys ever heard anything like this? Bruce?
I saw a mob movie once.
Mm-hmm.
There was a case in the mid-'90s in Florida, a big drug case with like 5 or 6 of the biggest criminal defense attorneys in the country at the time, Roy Black and Albert Krieger, and names that mean a lot to guys like me. a juror got bought off, and eventually one of the defendants who was acquitted was ultimately charged with jury tampering and convicted of jury tampering. But that's the only one, and I saw that on Netflix.
Netflix. Okay. Dane?
I talked to one of the lawyers who represents one of the defendants in the case, and those defendants are represented by the blue chip of the Minnesota Criminal Defense Bar. This man has practiced for probably 30 years, federal court, some of the most notorious cases, and he just texted me last night briefly and said, of all of the years of my practice, today was the craziest day I've ever seen. He said everybody was literally learning as they went, and nobody knew what was happening next, or they couldn't believe it as it was unfolding. It is wild.
It happened before their closing arguments. I imagine you guys as defense attorneys would really enjoy that being sucking all the oxygen out of the room of your closing arguments now shrouded in the fact that there was somebody trying to be bought off.
I just can't imagine unringing this bell if they try, what the appeals will be, all of it. It's just it's a true nuclear bomb into this case.
Well, and it's crazy because I think all the defendants are now in custody without any due process. We don't know who did this, but like they all just get vacuumed up into jail, and I believe that the jury is now sequestered like O.J. Simpson, like living in a hotel or something.
What's the threshold? That was easy for me to say for mistrial. Somebody asked that for you guys yesterday when I was teasing that you're coming on today. I mean, they said, how could this not be a mistrial? Ask your lawyer guys tomorrow.
Well, there can be a lot of reasons for mistrial. There has to be a fundamental defect so grave that it either impedes the ability of the state to get a fair trial, or it violates the due process rights of the defendant such that nothing can be fixed. I don't know what they're going to do here. It's been such a long trial. I think the judge is putting themselves in a very precarious position because nobody really understands in this district, in the District of Minnesota, what to do here. We don't have mob trials in the District of Minnesota.
If there wasn't extra jurors, if they hadn't sat some alternates, this would probably make a mistrial because you couldn't sit a full jury. But this is one of the times where if you're an alternate juror, you get to sit through a whole case, and then everybody gets walk in the little room, and they're like, not you. And so most of the time, in our case, we felt bad. You always almost go apologize to them because you think you sat here the whole time and you don't get to be a part of it. Well, this is their understudy moment to shine.
My time to shine, baby. Questions in for you, 35270. I cannot believe that it is legal for law enforcement to access DNA from Ancestry.com or 23andMe to attempt crimes, is what this comes in.
Well,
just read it as it comes in.
That's a failure of imagination because you should believe it. It does happen. In the old days, they used to be able to just do it, and Dane can talk more about this. Now there are more restrictions. So you can consent when you fill out the form to letting law enforcement access your data, but typically they need like a search warrant or a subpoena now.
It's a product of advocates in the space identifying this issue and fixing it. It also happened with Ring cameras. So before, when you would get a Ring camera, tucked in the service terms would be something to the effect of, we can give this to the police if they ask us. I don't know about external versus internal. That's probably a different analysis. But similarly, these 23andMe's, they would basically put in that terms of service that nobody reads, nobody looks at, that says, if we're reached out to by the police and they ask for your DNA, we can give it to them. And so once people figured this out, there was sort of a backlash and an uproar that this is my privacy. I don't consent to that because I just wanted it. Same with Ring. And so they've changed, in our opinion, for the better, so that now there's a higher standard that these companies can't just give it on their own.
There was a case early on with Ring where a bicyclist was driving by a house where somebody had gotten murdered, and law enforcement just pulled the Ring data, and this guy became the number one suspect for a long time, and his life was ripped inside out. He was 100% factually innocent. So there are more restrictions on all these data.
On the flip side of that, as criminal defense attorneys, there's been people that have been locked up that had not committed the crime. And DNA, all these years later, have proven their innocence. I'm curious your reaction. I mean, the way I read into what you just said is there's a process that should be taken to get there.
Yeah, I think if you give 23andMe your DNA and the contract offers you an opt-in where you want to put your DNA out there to either I guess, incriminate yourself one day possibly, or help solve crimes tangentially. I'm not a DNA expert. I think that's fine. My issue, and I think the advocates in this space, their issue was that it was happening without your knowledge or your consent.
We were talking before, as you're switching gears here, and if you have any questions or additions to that, 35270 so you can join the conversation. About there was a high-profile situation that just played out this week about a guy that called into court while he was driving, which I wouldn't advise doing. But then it turned into this whole national conversation of was driving with a suspended license, gets in trouble, and then it turns out that, whoops, that was an error on our part. Your reaction to that, Bruce?
Well, yeah, it's a bad look if you show up for court on Zoom for driving without a license and you appear to be operating your motor vehicle. The judge was a little bit apoplectic. As you said, in the fullness of time, it was realized that the guy had a valid license. Now, we have and do represent certain high-profile clients, and sometimes information about those cases gets out into the media and gets radically misinterpreted. For example, we have a client, there was a document from the government that seemed to imply they were found with drugs. And so all of these breathless articles were written about how this person had drugs. It was a boilerplate sentence, and it was completely misinterpreted. There's a reason we have due process. There's a reason we take facts, evidence, and proof seriously, and everybody should let the process play out.
I want to point out he said articles, not like broadcast journalists.
There was this clown, I think his initials were TA. I don't recall.
All those dang articles that were written. Just want to underscore that. Dane, you're about to add something.
Well, I want to close the loop on that guy from Michigan. And this is something that Adam Martin is one of the things he advocates related to mugshots.
F5 project, for those of you that aren't familiar, Adam Martin.
And that's the thing is, look, I watched that video. I dunked on that guy. I thought it was hilarious that you would dare call in, and the whole scenario, the whole internet did. People on late night television did. But I'll tell you what you're probably not going to see on the back end is any retraction, any apology, any explanation. This dude's life hopefully gets just back on track, but it was ruined for days. And that's also what happens in mugshot cases when you're ultimately found guilty or it's dropped. We as a society have a shiny object syndrome problem, and we love to laugh and we love to dunk and we love to jump to conclusions, but we are far less likely to go back and be like, eat a little crow. And so I'm sorry for this guy. I laughed at him, and I posted about it yesterday, and I think it's good, and it's a lesson for all of criminal defense. Oftentimes, it does turn out to be what it is. That's a fair part of our job. But because there is enough times when it's not, it's a little dangerous to get out there and put your stake in the ground and not be ready for some of these moments.
There is, when you, Dane, were a part of that whole situation when it comes to the situation out in Bismarck in Burleigh County, in which there was all the articles, everything that was written about a mother that was charged with the death of her newborn, and it wasn't true. That's going to live in infamy right now.
And Bruce was involved in that too. It's very important for me to say that. He was integral in that. And I don't know how much you've been following, and it's probably not exactly apples to apples, but just last week, the state Supreme Court reversed another similar case against a similar prosecutor for similar conduct related to a similar medical examiner where the person was found guilty of harming their child, killing their child, and the Supreme Court reversed the conviction for not the exact reasons, but similar. And I want to highlight that because I think there's a fundamental problem in some of the ways that law is practiced by that attorney's office in Bismarck.
Got to get a weather update from Too Tall Tom Schmancy. We'll come back, conclude this month's rendition of Law Talk. I got other questions coming in about juries. We'll get those when we come back. Question comes in for Bruce Ringstrom Jr., Dane DeKrey, about the Minnesota case, the Feeding Our Future, about the $120,000. In the Minnesota case, they're wondering, is there any way to track the $120,000?
Well, they're doing their best that they can right now to track it. Dane mentioned to me before that within hours, the FBI had secured, countless search warrants to try and get things. I suspect, have no evidence right now, but they're probably going to do what's called a geofence warrant. That is to say they will get cell site data from the cell site closest to where the cash was dropped and basically do a dragnet and gather up all the cell phones that were connected to that, probably use some tricky computer things, artificial intelligence to winnow it down. More likely than not, they will figure out where this cash came from.
They'll be pushing the limits of the Fourth Amendment because of it's such an egregious violation, in their opinion, of the fairness of a trial or just the sanctity of trial. We have seen these in history where these cataclysmic issues, and this isn't 9/11, this isn't things like that, but I would just be wary to watch about how your Fourth Amendment gets a little malleable in these situations.
Somebody's asking what happens to the $120,000 in cold hard cash.
Once everything gets litigated, if the government still has the cash, there's a couple of options. It can go into a general fund. Very often, law enforcement will have an asset forfeiture fund where they'll, maybe donate things. They'll buy, fund new equipment. Who knows? Maybe they'll build a volleyball sand pit for the FBI agent, something like that.
I'm sure that one pleased a lot of your law enforcement friends listening right now. It's a good way to end this month's a lot of talk. They can text you personally on that one.
Yeah, they can text me personally.
But when people want to reach out to you for your criminal defense expertise, how do they get a hold of you guys?
Well, you can certainly go online, ringstromdekray.com. You can also call us, 218-284-0484, 218-284-0484. Our main office is in Moorhead. We also have a satellite office in Detroit Lakes, Minnesota.
Very good. You guys have been always fun. Always a pleasure learning a little bit more about what's going on in the news, and, of course, people asking questions about what is, in fact, going on, because we always hear, yesterday you should have saw the text messages about juries that I was getting, and, of course, when they hear it from other politicians, which I know you guys have experience with when it comes to profiles and having a client that's both a public figure in public office and then trying to find away from those articles, or how you get to, that fair trial there. So it's a lot of work, but I appreciate you guys coming in and peeling back some of the layers for us.
We're happy to be here, Tyler.
We'll do this again next month on the first Wednesday. How's that sound? Unless you guys have other work that comes up again.
No, yeah, we are gearing up for another trial. I think about a month ago we were telling you this is the summer of trials.
Yes.
So tomorrow we have a big motion hearing about some stuff in the case. Otherwise, we would have been here tomorrow, and we will be back on Wednesday going forward unless something more important
more important than just talking to me. That's defending you. That's what they do. So if you find yourself on the wrong side of the law, that's quite frankly who you want to call is Ringstrom DeKrey Law. Tomorrow we got a full lineup for you again. We did have some reports about some cell phone issues, telephone issues today. Derek Hanson's got the Draft Time News coming up here in about 4 minutes, and he might have more information for you. But folks, I'm looking at the clock, and this is it for me today. I'm Tyler Axis, your host here on Afternoons Live. I'll be back for more of the show tomorrow. Telling you, drive safely. You take care of yourself. I'll check in right here on 790 AM, 94.1 and 104.7 FM, KFGO.